Okay, well, good afternoon and welcome to Time to Get Your Together. Here we'll discuss everything from estate planning to how to avoid a probate administration and everything in between. I am so excited to introduce to you Samantha Fitzgerald. Most of you know her as Sam or Samantha. Samantha is an attorney in plantation, and her firm is 100% focused on estate planning and probate and trust administration. She has been practicing for over 20 years, and doesn't she look great? She's a CPA and has an LLM in tax. And for those of you, I am Bianca Moreras, and I will be your host and moderator today. I am a business development and career transition consultant, and I bring coaching of over 36 years of experience. I concentrate with law firms and lawyers, but I have the ability to help any company bring them to the next level and aspire to every dream that they want to come true. So without further ado, I will start our questioning. Welcome, Samantha. Welcome, guests.
Thank you, Bianca. I did just want to clarify that today's topic, so we're going to try to do a different topic on each of these Zoominars. And today's topic is on powers of attorney.
Awesome. Thank you, Samantha. So our first question is, what are some examples of when I would use a durable power of attorney?
Great question. So in my opinion, a durable power of attorney is oftentimes the most important document, estate planning document that you can have, because there's no replacement for it. If you're incapacitated and somebody needs to help you in some way, which may be paying your bills, finishing a real estate transaction that you may have been in the middle of, continuing to run your business and pay your employees, talk to your credit card company, talk to your mortgage company. The only replacement for this is a court-appointed guardian, which is a horrible experience. If anybody's been through a guardianship proceeding in court, it's a horrible experience. Not only is it extremely expensive, it's extremely time-consuming. All of your assets now go into court supervision mode, into a restricted account, and it's not your own anymore. The court is in charge of it. So the durable power of attorney could be used, as I kind of mentioned, to continue paying your bills, to pay your mortgage, to pay your FP&L bill, to call up FP&L and speak to them on your behalf, to speak to the hospital about a medical bill, to continue your business running, to pay your vendors, to pay your employees, to go to your bank and pull money out, to access maybe the cash value of a life insurance plan, even though you're still alive, but maybe you need some cash to pay medical bills. A durable power of attorney can literally be used for almost anything, almost. And in the absence of it, it's a real tragedy. As a quick example, even married couples, a lot of times they think that just because they're married, they can do whatever they need to do for their spouse, and that's not accurate. Go ahead, Bianca, you can say something.
Well, actually, that leads me to my next question. If I'm married, do I really need a durable power of attorney for my spouse?
Absolutely. In some instances, you don't. So if you have a joint bank account with any joint owner, either joint owner can access 100% of the funds. But just because you're married doesn't automatically give your spouse rights over your assets, property, or financial decision-making. So as a simple example, if you own a home together and you wanted to sell the home or refinance your mortgage or get a mortgage, sometimes people want to get a reverse mortgage because they need cash. You need both parties' signatures to do any of those things, even if you're married. So I've had several instances where people call me and say, I'm in the middle of refinancing our mortgage, or I'm trying to sell the property, and my spouse, they either have dementia, early onset Alzheimer's, sometimes people in their 50s or 60s. Something physically happened, they're incapacitated, but they're still alive. And guess what? You can't continue that transaction, or you just can't do it, to begin with, because you need both parties' signatures and consent. And in that case, you're stuck going to court and becoming your spouse's court-appointed guardian, which again is a horrible experience. So no, just because you're married doesn't automatically give you rights over your spouse's assets or property. And you absolutely should have a durable power of attorney in place between spouses.
Well, there goes the theory that I thought I was in charge of my husband, but there you go. Okay, so can I continue to use the durable power of attorney after a principal has died?
No, it terminates upon death. I see this problem so often where people come to me and they say, I was my mom's power of attorney, I was my dad's power of attorney, and now the bank is telling me I can't get this money. It has to go through probate. Why is that? Well, guess what? They thought that they were on the account as a joint owner, when in fact, all they had was the power of attorney. And it's good to have a power of attorney, but they were transacting business thinking they owned this account with this person, and they didn't. They had the power of attorney. And immediately upon death, that power of attorney terminates. And again, I have lots of people come to me and they say, but I was their power of attorney. Why can't I do this? Why can't I get that? Because they died. And as soon as they died, the power of attorney becomes ineffective. It terminates. So it's really important not to have just one thing, but to meet with a lawyer, a qualified estate planning lawyer, whether it be me or somebody else, and fully understand the situation, have all of the documents that you need, and don't do this in a vacuum. Make sure, one of the things, sometimes people get documents online, or they work with a lawyer who maybe really doesn't specialize in estate planning, and they have a couple of documents and they've done a simple will. But we do comprehensive planning here, where we really discuss everything. And we ask the questions: are you on the bank account? Should you be on the bank account, or should you not be on the bank account? What assets are there? How should they be titled? Should there be beneficiaries on them? Who should those beneficiaries be? Alternate beneficiaries. We really have a very comprehensive conversation about these things. So hopefully with our clients, those problems are not going to happen.
Awesome. Wow. Okay, so we need to look at the full package. We're not just looking, like you said, in a vacuum. So people keep that in mind. Sometimes we're rushing out to do things and we piecemeal them.
Yeah.
So
any questions? I'm just going to say, people, feel free to put them in the chat box, and Bianca will ask them of us, or you are free to speak if you're comfortable talking. Feel free to ask us a live question, and any questions that don't get answered during our allotted time, because we're trying to make this short for everybody to be able to attend during their lunch hour if they're working. We can always, you can stay after the program and continue to ask, or we'll answer them separately.
Awesome. Thank you for that, Sam. So I have another question here. Can the durable power of attorney be used to make gifts? Christmas is coming.
Excellent question. I'll give you the famous lawyer answer. It depends. So durable powers of attorney are excellent documents to have, but they are abused often. So any third party relying upon a durable power of attorney is going to be skeptical to some extent. So a lot of times people try to use a power of attorney to make a gift to themselves. For instance, I had a situation where we handled a probate administration because there was a property owner, mom. She had 3 children. Everybody got along. Nobody was doing anything wrong. Before mom died, they did a deed and they transferred her property to the 3 of them. Okay, that's what was going to happen when mom died anyway. They figured, let's avoid probate and, let's get this property out of mom's name. Mom dies, they go to sell the property. Well, guess what? The durable power of attorney did not give them the power to make a gift. didn't give them the power to make a gift to anybody, but it certainly didn't give them a power to make a gift to themselves. So it has to be very clearly written in the power of attorney what the powers are. Certainly a gift to yourself, it better be very clear that the agent, that's the person that has the power under the durable power of attorney, has that power. As far as gifts to third parties, it still should have that power, and it will kind of depend on the situation. But if the intent of the principal is to give that power to be able to make gifts, it absolutely has to be very clearly written in the durable power of attorney itself.
All right. Well, I do have a question here for you from one of our guests, and it says, upon death and the durable power of attorney stops being effective, how does business get transacted after that?
So it will depend on the asset, but assuming the asset was in the individual, the decedent's name, you will have to open up a probate administration. That asset will pass through the probate administration. So nobody will be able to manage the asset until somebody's appointed as the personal representative in the probate administration. Or again, depending on the asset. So let's say it was a bank account and you were transacting business on the bank account using the durable power of attorney, and then the principal dies. Well, if there's a beneficiary named on that account, the account's going to go directly to that beneficiary. So the power of attorney terminates, the account is frozen, and it will pass to the designated beneficiary, even if that's a different person from the power of attorney. If there's no beneficiary on the account, then we're back to the probate situation. So until, it might take a couple of months for a personal representative to be appointed by the court. Once they're appointed, then they'll be able to transact business on that account. And depending on the circumstances, the court may require the personal representative to either post a bond, or especially in Dade County and Palm Beach County, it's very common that the court will require a restricted depository. So even though you get appointed as the personal representative, you can't just immediately jump in and start transacting business and have access to the funds. They require that the funds go into a special account, and you can only access the money with a court order. So people really, really get caught off guard with these durable powers of attorney terminating at death, and they don't realize that it's not going to be good anymore.
Wow. So some really good steps need to be taken for that not to occur, for sure. So I do have another question here. When does a durable power of attorney go into effect?
So if you're executing one now, they're effective immediately upon signing. I'll talk about that a little bit more in a sec. If it's old, prior to 2011, the law kind of changed in mid-year, but around that time, so let's say 2010 or previous, it could be either way, either immediately upon signing or only upon the principal's incapacity, which we call a springing power of attorney. It springs into existence upon incapacity. But anything 2011 or forward, it's going to be immediately upon signing, which means you are perfectly fine. You're not incapacitated. You're not sick. You're not hurt. None of that. The person you've appointed in that document can use it. They can take that document to the bank and withdraw all your money or sell your property. So that sounds really scary, right? Like, why would anybody sign a power of attorney? Because of all the reasons we talked about before. They're super important, but you have to safeguard them. I've seen horrible things happen with the durable power of attorney, but you have to safeguard them. For number one, you have to appoint people that you trust. Absolutely. That's the first line of defense. Appoint somebody that you trust. You can appoint two people together so that they have to make decisions together. So there's some oversight there. I don't like more than two because that becomes very, very impractical and unruly. But what I always tell my clients is don't give them the power of attorney now. You hold on to it. You keep it in your documents. I have some paranoid clients too that leave the original with us and they don't even take a copy home with them. So we safeguard it for them, but you don't ever give it out now unless you're comfortable. If you're an older client and you need your child or whomever you've appointed to step in now and start helping you manage your finances, and that's okay. Other than that, just hang on to it and make sure everybody knows you have documents. They know who your lawyer is, but you don't hand it out now. There's no need to do that.
Wow, you're being so thorough because I had 3 questions and you answered all of them. Wow, Sam, you're pretty amazing. That's great. Again, a few people joined us. If you have a question, please type it in the chat. And in about 2 to 5 minutes, we're going to open up for some awesome communication, because with all this isolation, we absolutely need communication. So I do have another question though for you, Sam. What happens if I do not have a durable power of attorney?
So either nobody's going to be able to help you. So whatever it is that somebody's trying to do, whether it be pay your bills, run your company, pay your employees, pay your nurse if you have home health care, talk to somebody, maybe talk to the hospital about a bill, get your car out of the impound, sell your car if you're no longer using it, anything under the sun that you might need done for you. Either it just simply can't be done, or if it has to be done, that somebody's going to have to petition the court to become your court appointed guardian. And typically that's going to be it doesn't have to be, but usually it's an all or nothing thing. So once somebody is appointed as your guardian, all of your assets are now supervised by the court. All of your financial accounts are now going to go into a restricted account, which you need a court order to get any money out to pay your bills. Your real estate cannot be sold or mortgaged without getting a court order. It's an exceptionally restrictive and invasive procedure that should be avoided at all costs. Now, it's there for when we need it, of course. Thank goodness it's there. But it's certainly the absolute last resort that you ever want to find yourself in.
Oh boy. Well, you gave a whole new twist to me to guardian. I thought that was a good thing. Guardian angel, guardian watching me. And, I'm a little freaked out over guardianship. So, well, that's my line of questioning at the moment. So I'm going to open it up to everybody, Sam, so that any little thing, because sometimes we have questions that somebody else has, and we're a little shy and we won't ask them. Yes. So I'm going to unmute everybody and give you the opportunity. We could do it the old fashioned way, just speak up or raise your hand. And then that way we can get some questions going here. And if you stray out of the power of attorney realm, that's okay too. We're here to educate you. So if you have a burning desire or question, we'd love to hear from you. Anybody? Come on. Now's your opportunity.
Yes, I gotta make it. Okay.
Okay, so Danielle has a question.
Okay, so I'm clear on a durable power of attorney that once the person passes, that power of attorney is no longer in effect. If there's a beneficiary on any of the accounts, that automatically goes to the beneficiary and so on. That's fine. Now, what happens with the administrative end? By that, I mean the decisions that need to be made that are just operational. Let's forget financial, but there's so many things that need to be done when somebody passes away. Those decisions have to be made, right? So under what authority are those decisions made? Whether it's funeral arrangements, whether it's to close up a house, to shut down utilities, logistically, how does that happen?
Yeah, that's a great question. And I had some clients, potential clients in here recently, and they had really done a great job of cleaning up their lives and preparing for death. It was interesting. They weren't that old, but they had sold all their real estate. They had really tidied up their lives because they didn't have children. right? The most natural kind of person to come in and handle somebody's affairs. So they tried to make it as easy as possible for whomever was going to come in. And it was interesting because we had this conversation of, well, who has that authority to do these things? Because the power of attorney terminates at death. And then basically you're looking at usually either, if there's a probate administration, somebody's appointed as the executor. We call it the personal representative in Florida, but I'll just say executor for these purposes because that's what everybody knows. So once there's an executor appointed, that person's in charge of everything, for the most part. But if you've done proper planning and you don't have a probate administration, then there is no executor. So who's in charge? So it's interesting because it really kind of depends on the asset. So just from a pure asset perspective, they travel in on 3 different roads, really. An asset may pass by a direct beneficiary designation, in which case that particular asset is owned by the beneficiary, and that's it. Nobody else has any control over it. No personal representative or executor, no trustee, no power of attorney, nobody. The beneficiary owns that account and it's their responsibility to go collecting it. Then there's the path of probate, and that's the personal representative or executor. They're in charge of those assets and those assets only. And then you have a trust, whether it be a revocable trust with an R, an irrevocable trust with an I. Whatever assets are owned in the trust, the trustee is in charge of those assets. So oftentimes we have the same person kind of appointed in all these different roles, and that makes it a bit easier because there's one person wearing lots of different hats, but basically in charge of everything. And then you may have a situation where this couple that I was consulting with, they had no trust. They had no need for a trust, really. They were probably not going to have a probate administration, so they had no executor that was going to be appointed. They had no children. And they had some financial accounts that would pass by beneficiary designation. So it was an interesting conversation of, well, who's going to see to their funeral arrangements? Who's going to come in and gather up their personal effects? They had no property to sell. They lived in an apartment. So that was an interesting kind of practical issue. We discussed, leaving a letter of instruction as to what they wanted to have happen with their personal effects. They didn't have anything of any significant value. So it was more so somebody just, coming in and donating or taking things as mementos and that sort of thing. And then making their funeral arrangements. So, when there's children involved, oftentimes the children are the ones stepping in and handling those, or a spouse. When you don't have children or a spouse, then it kind of depends. I don't have a black and white answer for some of those things because it really depends on the circumstances and who steps up. If there's any fighting going on, if there's any, conflict, but the assets will pass either directly to beneficiary through the probate administration or through the trust. Those 3 paths are clear, but then you have those loose assets, your personal effects, your jewelry, which is an issue, but just your smaller things, which, well, where do they go? Who takes care of them? Some things have significant value, artwork, jewelry. If that's the case, then somebody better have some documents in place, or there's going to be a problem potentially because those things grow legs very quickly. And people come in if they have access to a place with a key. They come in and they just take them and they leave very quickly and never existed.
Well, I hope we answered your question. I do have a question in the chat for you, Sam. What are your alternatives if you don't have anyone reliable to be your healthcare surrogate, executor, or trustee?
Yeah, that's a tough one. So a trustee is probably the easiest one out of them all because there are corporate trustees. So as long as there's enough money involved, you can appoint a bank like a Wells Fargo or a Comerica or something like that, and they serve as corporate trustee, they usually want to invest the funds as well. So, you know, it's usually not a good option for, I'd say, an estate under $500,000. They charge a fee. They can be expensive. They can be very impersonal. I usually like it to be, you know, one of the last choices, unless there's a reason, you know, if there's conflict or we have difficult beneficiaries, maybe somebody with substance abuse or anything like that. But if there's truly nobody to choose, then it's a perfectly good option. It doesn't have to be family. So always know that it can be friends. It can be more distant relatives like nieces, nephews, cousins, but it can be friends if you trust them. And it can be your lawyer, or your CPA, your financial advisor. If they do that, a lot of financial advisors can't or won't do that. But it can be anybody. If you truly have nobody, then you have nobody. Sadly, I do meet with people that come in and, you know, I don't know them very well, and they come in and they have no children. They don't want to appoint their children, and they really have no friends, and it's very sad. You know, and the older you get, unfortunately, the pool shrinks because people start dying. So it can be a really tough situation. So for the trustee, you have the corporate trustee. For healthcare, obviously, that's the most personal of all issues. So that can be challenging. Power of attorney, you just have to really be careful because it's such a powerful document. So you want to make sure that you're just not appointing just anybody. In that case, sometimes a guardianship is better. If you truly have nobody to appoint that you can trust, you may want a court-appointed guardian so that hopefully, you know, your assets are going to be secure, and it's going to be court supervised. So they're not always bad, usually bad, but not 100% bad.
I just want to put out there, I'm adoptable. Does anybody have any other questions? I'd like to be sensitive to everybody's time. Anyone? We have
Yeah, I want to hog the show, but I do have a question.
Okay.
I understand the three ways, you know, the direct beneficiary, probate, or the trust, right? But at first you said there should be a personal representative or executor. Where does that come from?
That's the probate. Yeah, that's the probate administration.
Oh, that would be under the probate.
Yeah.
It would be assigned by the court.
Yeah, if there's a need for a probate. So remember that only certain assets have to go through probate. No beneficiary designation, not jointly owned, and not already titled in a trust. So not everything goes through a probate administration. And when you're doing your estate planning, that should be one of your goals, is that nothing goes through probate. So hopefully there never is an executor or a personal representative appointed.
Okay.
Peggy, you look like you have a question.
Yes, I do. How do you know if you need a trust versus just a will?
So most people probably need a trust. A will only controls the probate process. That's its only job. That's it. So if you want to go through probate, have a will. If you want to try to avoid probate, then most likely you're going to want to implement a trust. But that depends as well. So if you own any real estate, almost always, 99% of the time, we're definitely doing a trust, because we're going to put the property into the trust so that it doesn't go through probate. A life estate deed also avoids probate, but that's only appropriate in some circumstances. So typically, as soon as there's real estate involved, we're definitely talking revocable trust. But the trust provides a whole host of other benefits as well for your beneficiaries. It provides them creditor protection. It provides, for ease of administration. If you have 4 children or, multiple beneficiaries, if you name them as a beneficiary directly on the account, then all 4 of them have to go collecting that account. And then they have to figure out how are they going to pay your, maybe your last expenses or any debts that you might have had. So it's much easier for all the money to come into the trust, and then there be one or two people that are in charge that function like the executor, but they're really the trustee. They pay whatever needs to be paid, and then they make the distributions. When the money comes into the trust, instead of going directly to a person, if they are having credit problems, if they're getting sued, if they have substance abuse issues, if they are in the middle of a bankruptcy, if they're in the middle of a divorce, the trust is going to protect them. Or if they themselves are incapacitated, let's say you die and your child, maybe, God forbid, they have cancer and they're incapacitated, but the money goes directly to them. Well, that's a problem for lots of different reasons. The trust insulates all the beneficiaries. If they're receiving government benefits because they're disabled, if they're receiving SSI or Medicaid, the trust will insulate them. So there's so many reasons why we would use the trust. We still use a will. We don't not have a will, even though we have a trust, because we want, in case something slips through the cracks and it goes through probate, we want the will to put it into the trust. We don't want the asset to go directly to the beneficiaries. So we always use them hand in hand. But if you only have a will, if something doesn't pass some other way, it's going through probate and it's going to pass according to the terms of your will.
You need to make a trust.
Okay, thanks.
Yeah. Wow. That was an eye opener even for me. You think you can get around things, but wow. Thank you, Sam. Well, do we have any more questions? Sam is always available to speak with any of you. Her office is very efficient and diligent and kind. That's what we need in these times. Peg, do you have another question? Look, your husband is lurking about. He could ask that question. I see him. Hey, dude, how are you?
Hello.
You could ask the question. She doesn't have to be your spokesperson.
I wanted Peggy to ask because I'm not her husband.
Oh, okay.
But she has two grown children and she doesn't have a trust. And how can she prepare her affairs in a trust so that she can delegate what she wants done?
Yeah, so she should definitely have a trust, and in the trust, you're going to appoint who should be in charge. And then you name the trust as the beneficiary of those accounts, or you can title the accounts in the trust, but sometimes there's some downside to doing that. Either way, the money would go directly to the trust, and then whoever you appoint in there as your successor trustee would then be in charge. They'd collect all the funds. They're going to make whatever distribution, just pay any expenses that need to be paid. And then they're going to follow the terms of the trust, just like a will, except there's no court. You don't have to wait for, orders to be signed by a judge. You don't have to file things. It's so much easier, quicker, cheaper. And it provides all those, benefits that we discussed before. If the beneficiary is, deceased or disabled, credit problems, spousal issues.
That's great information.
Sam, can she do that with you?
Of course. Happy to help.
And what's that? Call you up and make an appointment?
Yeah, Andrea is also on the call here. She's in at least my top right. Just call our office and Andrea would be happy to get you all situated.
What does it does she need to bring all her documents, or does she need to sit down and learn a little more about it and go home and then bring the documents back?
Andrea will discuss all that with her, but usually, if you have any existing documents, you probably want to bring those to the consultation because we'll review them, and sometimes they may be okay. Like you may not need to make changes, or you might only need to add one document to it, or they might be completely out of date, but we're honest about what we review. We're not trying to do work that doesn't need to be done. Anybody who calls us, as a result of coming on our Zoominar, we'll waive the consultation fee because normally we do charge a consultation fee.
Woohoo! Anything for free is okay with me. So seize the moment, people. Seize the moment. Do we have any more questions? Because we want to be sensitive to your time. And again, you can, email Samantha or her office, and they'd be happy to help you there.
And And
I
we're
would
going to
like
be
to ask a
doing this.
question. Can you hear me?
Yes, who is this?
This is Christine.
Hi, Christine. Go ahead.
How are you?
Great.
Good. I've not met either of you, but I'm Danielle's sister.
You have a similar voice. I can hear it.
We're four girls, so we all sound alike. I wanted to ask, I created a trust in 2006. Since then, many things have happened. I've made one amendment to the trust, and there's a number of changes that I'm looking to make. And my take would be to just start from scratch, because I think there were a number of errors made initially and in the way that the trust was established. Is it best to start from scratch when I anticipate a lot of changes, or what do you recommend?
That's a great question. So when you make a change, so first of all, any documents that you do, you can modify, unless it specifically says you can't, like an irrevocable trust. So when you make a modification to a trust, you can either do an amendment, which is a separate document, and it says what it changes about the trust, or you can do what's called an amended and restated trust, where you basically do a new document, but the trust itself is the same, so that if you've titled any assets in it already, none of that has to change. That is almost, I'd say 99% of the time when we make a change to a trust, whether it's our own trust that we drafted or somebody else that comes to us and they have a trust in existence, we will do an amended and restated trust, because I hate trying to put 2, 3, 4 documents together and read them all and try to figure out what's going on. If I can't do it, if I have trouble doing it, imagine somebody else, because you don't have to hire a lawyer to administer a trust. So a lot of people are administering these trusts, these trustees, and they don't have any legal guidance. So imagine somebody, I had a client and her husband had made several changes to the trust. And, the problem is the amendment doesn't really follow the original trust. They may not be numbered properly. The language is different. It's a nightmare trying to work with that. So I will always recommend an amended and restated. Same trust itself, the underlying trust, but a brand new document. It's much cleaner and much easier for everybody to work with.
I see. So if you have assets titled to the original trust and you restate it, does that require changes to the way that these assets are named?
Nope, not at all.
So it always goes back to that original date.
Yeah. And in the new trust, it will say, I originally created this trust on this date. I've amended it however many times. And this new amended and restated trust is intended to, revoke all of those, not revoke, but redo, take the place of all those prior ones, but it's still the same trust.
I see. And something else that Danielle shared with me was that the moment you name someone in a trust, that person, upon request, can ask for all of the financials.
Yeah, so that's a bit of a technical discussion, but a beneficiary of a trust who is entitled to something other than just a specific dollar amount. So if you say, Eddie, you get $10. As soon as Eddie gets his $10, for the most part, he's done because he has no more skin in the game. But if Eddie is to get 25% of the trust, then Eddie has a lot of rights, and he's entitled to a lot of things. He's entitled to know how you calculated his 25%.
I get it.
So he needs to know what came in the trust, what went out of the trust, how much you paid the trustee, what expenses you paid. He's entitled to a copy of the trust. So we make a distinction between like a specific distribution and then what we call a residuary beneficiary, meaning they get the residue and they have a lot more rights.
Okay. Thank you, Samantha.
So, I'll add in there, a lot of times people want to leave $1 to a bad beneficiary because they want them to know, that they were excluding them, or they've been told it's better, to leave them $1 because, then they can't, fight anything. Absolutely wrong. Because now they're a beneficiary. It may only be $1, but now they're a beneficiary. So instead, just clearly say, I have intentionally excluded them from this document. That's clear. And then they have no rights.
Yes, okay, that makes sense.
Oh, beautiful. So are there any more questions? Because don't forget, there's going to be a series. So any more questions? We want to be sensitive to your time. Peggy?
Yes, I do have one more. If you are in charge of a power of attorney, do you collect a fee? Do you get paid to be that person?
You can, yes. So remember, as the specific role is called attorney in fact, you are a fiduciary. You're held to a very high standard of care, and you have to really be careful in what you do. Everything you do should be for the benefit of the principal. But you absolutely are entitled to a fee unless the document says otherwise. If it says in there that my attorney in fact shall serve without fee, then no, you're not entitled to a fee. But if it doesn't say that, then yes, you are. What that fee should be is where things can go sour.
Yeah.
It depends who you are, what your level of expertise is, how much time you've put in, the difficulty in what you're doing. So if you're serving in that capacity, absolutely keep track of your time and what you're doing. Keep a log, keep a record. Oh, this is a great blog post. So thank you for making me think of this. I'm going to blog about this. If you are, an attorney, you may charge more because you're taking time away from your business, to do this. If you're a homemaker, not that that's, not good, but, you can't show that you have an hourly rate that you are, taking away from your business. So that might be a little harder. So it really depends on what's a reasonable rate, and it will depend on what's customary in your area as well. So it will kind of depend on geographics and that sort of thing, but absolutely keep track of your time. Any expenses that you advance on behalf of the principal, you would be entitled to, be reimbursed for those for sure. It's a thankless job, though, I will say.
For sure.
And time consuming.
Absolutely.
Very.
Absolutely. So we hope that you enjoyed this series. The time now is 12:44, so we've gone over in our time, but we're happy to be here with you. So please know that that's just an observation. I wanted to thank everybody for coming to Time to Get Your together. And we want you to know that we will be meeting the third Friday of every month for 30 minutes or more. And think of your questions. This is a great opportunity. And please take the time to meet with Sam if you have curiosity or need your documents in order. We would love to have that opportunity to spend some time with you. So we hope you have a fabulous Thanksgiving. In this time, there's lots to be thankful for. And, we should just be looking in that direction. We hope this benefited you in some small way. Any last parting words, Dr. Sam?
No, thank you everybody for coming. This was fun. I really enjoyed this. I'm looking forward to all of our other Zoominars. Each month will be a different topic, but I'm happy to get off topic as questions come up. So please tell your friends, join us, and have a wonderful Thanksgiving. I'm sure we'll all be thankful that 2020 will be over soon. That's it. Thank you, Bianca.
Thank you so much,
Bianca, for moderating. We appreciate it.
We'll see you next month, and keep an eye out. Please invite one more person, because guess what? We're all going to pass.
Thank you.
Take care of yourself. Have a great night. Bye-bye.
Bye.